She's got some right here. I just don't want to trip on that wire.
Thank you. I was going to get to that.
So it's going to make me fall.
Yeah, I know.
That would have been embarrassing.
I can't believe it would happen here. I'm sorry, I'm Susie.
The judge wants to, can you do it without? Yeah. One still camera. Media's going to sit right there. All right, circuit court sound session.
All right, good morning. Please be seated. Good morning. Okay, first of all, when I say 8:30, I mean 8:30. So be in this courtroom when I say we're going to start the trial. We've got a lot to do. The jurors probably will not be up. My guess is probably 9. Yeah, it's going to take them a while to call them because there's 200 down there. They've got to do a random, roll call. They got to send them up. It takes time to get 100 people up here. We got to line them up. But there's some things I want to do before we get to that. 2 are scheduling issues. The first is, and they both involve Mr. Rosenfeld. Well, the defense and Mr. Rosenfeld. First, I've thought hard about this, and Unfortunately, I'm not going to be able to accommodate your request not to be in trial Thursday and Friday. Candidly, I hate to do that, I really do, but it would be naive of me to think in a trial like this that issues aren't going to come up, which are going to extend the case. Give me an extra 4 days off where I've got to worry about trial publicity. And even more importantly, I have 2 speedy trial cases that must immediately proceed after this and be tried in December. And I have a limited number of trial days in December, so I just can't accommodate the request. I do apologize for that, Mr. Rosenfeld. I normally would. I just can't do it. The other, though, is with respect to your request to put on additional evidence on the tape at Chili's, which is what we were discussing yesterday. You indicated you have additional evidence that I've not previously considered. Is that correct?
Yes, Your Honor.
Okay. What I'm going to do is I've gotten Judge Kasternakis to take my morning calendar on Monday. And so Monday at 8:30, before this trial actually starts, we should have the jury picked by then, hopefully, but before the trial actually starts, I'm going to give you the opportunity to put on that evidence with respect to the issue at Chili's, the malfunctioning recording device. Now, I don't want redundant evidence, obviously evidence I've already heard and considered. I don't want that, but you said you have some additional evidence that I've not had an opportunity to consider. I'm going to give you that chance on Monday morning before we get the trial started, okay?
Yes, sure.
All right. Okay. Also, I guess I might as well deal with this. There was a motion filed this morning. I thought it was going to be the motion to suppress. Has that been filed yet?
No, Your Honor.
Okay, so you're going to get that filed today, or?
I thought this weekend, since they would have time to prepare, but I can do it tonight if time would occur. I just thought we're starting at 8:30.
Well, we know what the issue is, I suppose, but I've got to, the problem is I have to have time to hear it. And I'm not sure when I'm going to hear it.
I think it might make sense to do it Monday morning if we're going to have some hearings that morning.
We are, but I wasn't planning to make it an all-day event. I'm planning to get the trial started on Monday morning. So,
That should be a 10-minute hearing. It's all argument. It's not evidentiary.
oh, well, it's your motion, so the state has to look at it, though. The state may, since it's a motion to suppress, I don't know whether they're going to want to call any witnesses with respect to it or not. Probably I couldn't hear it before Monday anyway, but I think it would be better. It doesn't have to be filed today, but I think, by tomorrow, at least a bare bones motion. You've identified, Ori Tennis, what the issues are, so the state has some idea, but I think you need to put something together so we have an opportunity to get it done timely. And then, Mr. Williams, I guess you'll have to look at it and decide whether you're going to just rely on the record that already exists or whether you're going to try to call additional witnesses. It'll be up to you. I think Mr. Rosenfeld's indicated he's going to rely basically on testimony that's already been offered either at trial first time or in deposition. And I'm assuming it has to do with Mr. Shaheda because it's my understanding is the issue is whether the consent given was voluntary or coerced. So I don't know. Mr. Shaheda would be probably, well, I don't know. You could have law enforcement witnesses about that. I don't know. So I think you need to get it filed before the weekend, Mr. Rosenfeld, just because I don't know what witnesses they may call. Okay? There was an additional motion filed this morning. I thought it would be the motion to suppress. That's how I started this conversation. But it turns out it's a motion directed to individual voir dire. Since we have time, I need to give you the opportunity to argue the motion. So go ahead if you want to take that up.
Yes, sir.
Did you get a copy of the motion, Mr. Williams?
I did, Judge.
Okay.
The reason we're not getting any motions, he's filing them in the regular open division drawer. So rules require once there's an unknown prosecutor, if file it as an prosecutor, he shows the file in the open division. That's why we're not receiving it.
All right, but you did get this one.
I got this one.
Okay.
The whole ones he said that I received yesterday, he's filing them improperly.
Your Honor, I've sent a courtesy copy to yourself, Ms. Lori and Mr. Williams. Every motion I can show you the return receipt, so I don't know what Mr. Williams is talking
I
about.
told them, they said that he went to Division W General Document.
I've also sent.
Okay, look. This is the kind of thing I'm not going to spend significant time on. The instruction is as follows. From here forward, anything that gets filed, make sure you send a courtesy copy. Just don't file it to the Division W General CAD. Send a courtesy copy to each other, and we won't have this problem, okay? But with respect to the motion that's currently before me, Mr. Williams, you have had a chance to see and review that motion. Okay. Ms. Rosenfeld, I assume you're going to be arguing that motion, so go ahead.
And just briefly, Judge, this is the issue addressed in the first appeal. They had asked for individual juries, individual voir dire in the first case, the first trial. And,
On publicity.
What, Your Honor?
On publicity.
Yes, Your Honor. And this court denied that, and that was one of the grounds for the duress when overturning the case. And to quote their holding, we conclude that the court erred in refusing to allow individual voir dire questioning and failing to strike the jury pool. And they did a very similar voir dire to what Your Honor intends on doing, having people raise their hands.
Well, I don't mean to stop you, Mr. Roosevelt. There's a very big distinction between the way I do it and the way it was done before. And the distinction is an important distinction because the procedure that I'm using has been approved by the Florida Supreme Court in first-degree murder cases. So this is not a new procedure. The mistake that was made in the first trial was that once people raised their hands and identified themselves as a person with knowledge, a conversation ensued in the presence of all the jurors concerning what that knowledge was, and that tainted the pool, and that was the holding of the fourth. I do not intend to do that. What I intend to do is I intend to have them raise their hand if they think they know something about the case, that each one of those people that express that they have knowledge about the case will be individually voir dire. Everyone else will be out of this courtroom. We will speak to each of these people individually. I am also going to instruct all potential jurors that this is a continuing duty that they have. In other words, the problem with this is sometimes you'll read this statement of the facts at the beginning. You'll get a set number of hands that go up. There will be people that express no knowledge at that time of the case. All of a sudden a light bulb goes off. Day two, they suddenly realize, oh yeah, I do remember something about this case. So what I'm going to do is I'm going to instruct them that this is a continuing duty. If at any time during jury selection they suddenly believe that they may know something about this case, they're going to be instructed to raise their hand, to not tell me what that knowledge is, but just to tell me suddenly they realize they know something about the case. Any person that raises their hand, any person on a continuing basis that indicates they have some knowledge of the case is going to be individually voir dire. And so I understand your concern about individual voir dire, but the procedure that I put in place will provide for individual voir dire. There's no requirement for individual voir dire on other issues. It's the issue of publicity. And the procedure that was used is not the procedure I'm going to use. The only thing that's similar is they're going to raise their hands. After that, they say nothing about the source of the information, what they think they know. And then when we individually speak with these people, I'm going to start the questioning, and then both sides will have the opportunity to voir dire each person individually as to what they know, what effect that might have on them, whether they've reached any preconceived notions, all those things you'd want to ask these people. So I don't believe it's required either by the 4th DCA's decision in this case or in any other case that I'm aware of that you simply bring people in one at a time, read a statement of the facts, and then individually voir dire them. This is a more efficient way, but I also think it's a way that's been approved. So I'm going to give you individual voir dire. I'm just not going to bring people in individually read a statement of the facts. Everyone's going to hear the statement of the facts whether I read it to the group or whether I read it to them individually. So they're already going to be exposed to that. The question is, hearing that, is there anything there that triggers within them a memory of the case? And those people you're going to get a chance to speak to individually, both this morning and this afternoon. So if you're requesting something different, and I guess you are, I assume what you're requesting is each person, each of the 200 people that we have here come in individually and we ask them about publicity. Is that what you're proposing, Mr. Roosevelt?
Yes, Your Honor.
Okay. I appreciate your concern, but I believe I'm going to be protecting your right to an impartial jury through this procedure. I think this, like I said, this procedure has been used countless times. I've used it countless times, and I know it's been approved by the Florida Supreme Court in first-degree murder cases. So I think it's pretty airtight as long as you make sure the conversation is not overheard by or discussed amongst the jurors. That's the key issue.
And that was our concern with 100 jurors and 70 people raising their hands. People are going to start to talk, and that's going to taint the jury.
Well, they're going to be just... That issue comes up in every trial, whether it's publicity or not. They're instructed up front by me on a couple of things, and I'll just tell you what I'm going to do here. I'm going to instruct them up front before we even get started. Starting now, and through the entire trial process until they're excused in this case. They are not permitted to discuss, communicate in any way with anyone about this case, either verbally, in writing, electronically, in any form. They may not communicate about this case. They may not do any research with respect to this case, and I'll go through that. They can't Google names. They cannot do any type of research at all. They cannot listen to or read any news accounts of the trial. I'm going to instruct them in this case. I don't do this in every case. I'm doing it in this case. There will be news coverage of this case. I'm going to tell them up front. I'm going to tell them up front every time they come back in here. I'm going to ask the same question of them as we begin our session. Has anyone listened to or reading news accounts of the trial? I'm going to tell them they're going to be responding to that question under oath, and that they must pledge to me that they're not going to listen to or read any news accounts of the trial. Anyone that does, I just need an honest answer. I'm not going to, if someone slips up and sees something they shouldn't see, it's not like I'm going to immediately hold them in contempt, as long as they let me know that that's happened, so that we can do, again, an individual voir dire to make sure that there's no problem there. But I'm going to cover all those things before we even get to reading of the statement of the facts. We have to trust that jurors will follow my instructions. Sometimes they don't. In any case, as you know, if they don't, I have to deal with the consequences. I have to figure out what's the prejudice, what's actually happened, etc. But all I can do is tell these people the rules, tell them this isn't a request from me, it's an order of the court, they must comply with this, and then see where we go. Now, in terms of the number of people that we're going to have to individually voir dire, I simply don't know at this point. I mean, I don't know. Well, as soon as I ask that first question, you're going to see how hard it's going to be to pick a jury in this case when we see how many hands go up. So we'll just have to wait and see how that goes. Whether 200 is enough, I mean, there was a barrage of news coverage over the last 24 hours, including this morning, and so I don't know what effect that's had on this jury pool. And we'll just have to wait and see. But I won't know until we get started with the process. Is there anything else logistically or anything that anyone wants to raise while we have a few minutes before the jury comes in? Okay. Yes, Mr. Claypool. Good morning.
I wasn't here yesterday. I was traveling. I just wanted to know the course schedule. We're starting every day 8:30. We're going to 4:30, 5 o'clock.
The normal schedule is going to be, well, for the next 3 days, it's tomorrow and Monday, the schedule is going to be 8:30 to 5. After Monday, I really do not, at this time, I've not asked anyone to cover my morning docket, which means we won't be able to start the case probably till 9:45 or 10. Each day, we're going to try to conclude by 5 o'clock. That's the ideal trial schedule. There's some variability in that depending upon whether we finish up a witness early. I'm not going to put on another witness at 4:45. We could break 15 minutes early. We may have to go a few minutes late to finish a witness. In other words, there's some flexibility in that. Next 3 days, typically it'll be 8:30 to 5. After that, it'll probably be typically 9:45 to 5, something like that, unless I get a volunteer to handle my morning docket, which I did on Monday, but I did that so I could accommodate the additional evidence that Mr. Rosenfeld wanted to find.
And then a lunch break.
Usually it's an hour and 15, and today it's going to be a little shorter. It'll be an hour today because I'm trying to interview 200 people, but typically it's going to be about an hour and 15 minutes. Typically I'll try to break at about 12 o'clock to 1:15. But again, there's some flexibility depending on who's on the witness stand. Sometimes we go to 12:30, and it'll always be about an hour and 15 minutes, except for today I'm going to try to take an hour break because we have 200 people I have to talk to. And so I'm going to try to do this group here in the morning by the lunch break and start the second group at 1 o'clock. But typically you're going to have about an hour and 15 minutes for lunch. The break will be about 12:30, depending on witnesses.
Just for appellate purposes, you're denying the motion?
Denying what motion? Oh, the motion for individual voir dire under the protocol that you proposed. Yes, I'm going to use, to the extent that you're asking me to bring in each person individually and not use the hybrid method that I've outlined, I'm denying the motion. I am going to give you an individual voir dire, but it's only after they've raised their hand and said they have some basis for knowledge in the case. So I guess I'm denying in part, granting in part, but I'm denying the procedure that you're suggesting. All right.
Yes, sir.
Okay, any other questions? State? Mr. Williams? Okay. Except for except for follow-up on publicity, you guys probably are not going to have much opportunity to do much today, so it's pretty much on me. Okay. Neil? We've...
Last I checked, they were working together to send them home, so.
Okay, so you'll have to line them up. Okay, the attorneys should also be aware that during the course of my opening remarks, very quickly on, I'm going to give you a chance to introduce yourselves. Because I do want to find out not just whether anyone's recognized the case, but whether anyone knows anyone, obviously. So I'm going to do some introductions. I'll introduce the courtroom personnel, give you guys a chance to introduce yourselves. Again, if they raise their hand, I'm going to ask them who they recognize. If they say Ms. Dippolito, that's as far as it's going. They're not going to tell me anything else. If they tell me they recognize me, which I've had happen, or Mr. Williams, or someone else, or even if they say Mr. Claypool, because Mr. Claypool wouldn't normally be here except for this case. If they say we recognize Mr. Claypool, that may have been from some form of publicity. So I'm going to basically, if they say they know Mr. Claypool or Mr. Dippolito, I'm going to say, okay, thank you, we'll talk to you about that later, and we'll do that on an individual basis. Okay? All right, I think what I'm going to do, if there's no questions at this point, I'm going to step off for a couple of minutes. It's going to probably take, my guess is at least another 15 minutes to get everybody up here, then Neil has to line up 100 people for rows. So it's probably going to be at least 15 minutes before we get back together. Anything else we need to discuss at this time? We're for right now? Mr. Claypool, Mr. Rosenfeld? Okay. All right. All right, we'll be in recess for about 15 minutes until we get these folks up.
Laura? Yes, hi. Nice to see you again. It's so funny, huh? True. It's so funny. Too much gambling. Small bag. Kids side. So I watch it. Threw it in my bag. And then last night. Last night.
They made every temple request for it.
Double fudge chocolate. Did you see that? It's like double fudge chocolate chip. That's like my comfort.
I know if you look that up now. If you want to look it up, you can.
That was a website, not
No, that's this one. I wasn't like, let's see. That other stuff. That's probably good. So this guy is gonna talk to the media. That's what he said in his book. Does she really been talking to me?
Seems right, right? Well, it is, but sometimes I switch it out to see what's on the opposite. Sometimes. If it doesn't work, I switch it.
That's why I didn't think of it.
Well,
Holy moly.
turn it up a little bit to make sure. And it goes a bit.
Yeah, if you would, that'd be great. I already want it.
We get into them now.
Make him the best effort to talk. That's just true.
should shout out to the it's always people's girls that you're reading.
Yeah.
Oh, perfect. Is mine okay?
Friday or Saturday? Did Michael go? Did you write down the book? No. I'd rather just work a day extra as opposed to do a whole for the whole day. What did she say? Did you ask about that? No.
I hope it was before that, and it was included, there's a good chance that things in the negotiations by date. I mean, I'll obviously not gonna cover the whole trial and then pass it off to a reporter, so I'm gonna come in, I'll take back the case. They're not gonna give me the case, because I'm happy to my case.
So like he had the time off, he was specifically 12 weeks ago that he was going to be dayside on Friday, and now they want him to nights. And he's like, I'm going to have to cancel my test. I was like, no, put your foot down, because if you don't, then they're going to run all my fingers.
You know, when they have things they have to do,
Oh, see, Cloud. And they take doctor's appointments on the day of work. We don't do that shit.
You okay?
There's no cafecito today. Have you met Karen before?
Hi.
This is Michelle.
Nice to meet you. I'm so embarrassed to see anybody today. This is my eye. This is my whole face is swollen. I don't know what, I think it was a scar or something. And I was just like, lolling out like it's paralyzed like this. So, yeah, I've never really gotten one scare.
I think a lot of times when you're like the temperature change, like that would be triggering. And then I would just put like hot towels on
Yeah, hot compresses.
Hot cotton presses. I brought it, washed them off. I thought I would do it. It just hurts. That's the main thing. I feel like I had one eye. Oh, I never wear my glasses. So
Karen produces on freelance for ABC and NBC.
today I can see. And you're with
She's PTV with us.
Sam. Oh, okay. Have you met my friend Alex yet?
Yeah.
Yeah.
Yeah, she also knows Alex, which is the new reporter at 25.
Oh, I don't think I've met him.
He's nice, isn't he, Karen?
Yeah, and the weekends now I think. Oh. Yeah, I was down in Savannah the first day and I was babysitting. And I was on call Sunday and Monday. Didn't have to go back.
Oh, good for you.
So this is
Just probably, I mean, if they have me do, if this is my morning lash out, then I'll be here until through 11, but
You'll have like stuff like already written from overnight that you can use. And I'm sure they might once it comes in, we're kind of a 60.
did you look into exactly why the appellate court threw it out? And so they ordered. Did they order a retrial? No. But that's why I was wondering whether, because it was dismissed, why couldn't they retry it again?
Because
Wouldn't it be,
the jury will absolutely make it if there's any reason to believe the jury's full of them.
But in that case, they should have called it a mistrial and
Right.
ordered a retrial.
Right. I'm not sure.
Not dismiss the case altogether. Because then in that case, I would have thought it would have been, what is that law or whatever, that you can't be tried twice for the same crime?
I wasn't here.
In front of everybody.
Well, they asked in front of everybody, everybody answered in front of everybody. And then
Like gain that.
And so the attorneys did ask if they could individually ask the judge to hear minutes, and the judge at that time denied that. So we did that.
So that's something we can talk about in 11 o'clock trial chapter.
So that's what they said in the jury pool.
That's 10.
Yeah, that's how they did it. Or such description. Where is it? Yes, so.
I'm sending to the web team.
That's what he's saying.